Good morning to today's Boardroom Bites at 9. Our topic for this morning is Directors and Officers Liability Insurance post-COVID-19. I think a very relevant topic and something a lot of people have questions around. And we've got a terrific expert with us this morning, Teri Solomon. Teri, if I can ask you to put your video and mic on as well now. Teri is an admitted attorney. She's got over 20 years of experience in the insurance space, as well as dealing with D&O insurance programs and claims. So Teri, you've got a wealth of knowledge on this topic, and I know, one of the acclaimed experts in this field. So I'm sure the guys are going to have a million questions for you when we get to the Q&A. And I'm sure if you've got any specific questions that you'd like to ask, we've shared Teri's details. Teri's details will also be shared with you post the session, so you can always get in touch with Teri to discuss any particular items that you need to go through if we don't manage to go through your questions this morning. So Teri, I'm going to hand over to you. I'm just going to give you the control of my screen. I'm going to hand over to you, and I will see everyone later on after the Q&A session.
Thank you. Good morning, everybody. I'm just trying to see if I can get control of Vakeshni's screen. Not yet, Vakeshni. Do you maybe want to then change the slides? I'm not sure. I'm struggling to get control of your.
Okay, I can do that for you. You do have control, but I can move the slides for you. If you just say next, I'll do that for you. Okay,
perfect. Good. Thank you so much. Well, good morning, everybody. It's such an honor to always speak at these IOD functions, although it's not a function. I recently celebrated my 20th anniversary, if you like, or association with the IOD. So it really is an honor to speak this morning. I think some of you are probably looking at my photo and thinking I don't quite look as good in my photo as I do today. My excuse is that that's my pre-COVID photo, when the world was normal and when the insurance company had literally not lost the plot as they have now. So that's my excuse. I've been asked to talk this morning about Directors and Officers Liability Insurance, and particularly post-COVID. So next, if you can go to the next slide. I thought what I'd cover off this morning are what are some of the risks that are driving what we call the hardest insurance market, particularly in the Directors and Officers space, in over 2 decades, and why, unfortunately, we don't think that it's going to get any better, at least for the next 2 years. Now, I've been around for a long time. I've been doing this for a long time. I was around when D&O really was first advocated in South Africa. I've been around where we had 3 billion rand in local capacity, where there was an abundance of capacity, where there was lots of competition, where the premiums were really, really affordable, and the cover was exceptionally wide. And that's the exact opposite where we find ourselves today. The other thing I'll briefly address is some of the COVID-19 claims, and these are claims directly as a result of COVID-19, with the caveat that these are US-based claims. To date in South Africa, we haven't seen any direct COVID-related claims. And I do think that given the current litigation climate in South Africa, as well as some of the recent judgments that have come through, that I don't think that we're going to, in South Africa, see the flurry of claims that everybody is advocating. I'll also talk a little bit about the business judgment rule, which I think, given some of the trends we're seeing and given what COVID has ushered in from a value creation perspective, is going to be absolutely critical for boards to get their heads around and to understand just how important the business judgment rule is going to be for them when they are challenged around the decisions that they make going forward. I'll touch on the D&O market, and you should probably strap yourselves in for that, because I am going to be talking about triple-digit increases and some pretty hairy stuff. And finally, what I'll do is just give you some ideas and touch on some of the things that we're doing for our clients, preparing for their 2021 renewals, and of course their Q4 2020 renewals. Good. So we can move on to the next slide. I think there's no doubt in everybody's minds that COVID-19, coronavirus, is the black swan event, that many of us in our lifetimes certainly will experience. And I think it's also safe to say, and certainly from the research that I've done, that there is no one country, no one company, and no one individual that could have ever prepared for a pandemic of this magnitude and the effect that it would have on the globe. You know, it's the stuff of Steven Spielberg movies, but the fact is we're living through it. From a management liability perspective and from a board perspective, what Coronanomics has ushered in is definitely a paradigm shift to value creation in all its forms. Now, this shouldn't come as anything new to boards because, you know, with the insights and the innovative thinking that were already proposed in King 3 and King 4 around integrated thinking, around integrated reporting, it shouldn't come as a surprise. But I think what Corona has done is simply amplified or sped up the need for companies to ensure more than ever that they create sustainable value, not just for shareholders and profit at all costs, but obviously for employees, for clients, for third parties, and of course for the environment. The trick, or shall I say the challenge for boards of directors is of course to balance all of those conflicting interests between the many stakeholders, all whilst acting in the best interests of the company, whatever that's going to mean going forward. And of course, off the back of unprecedented personal liability, knowing that every decision that they make is going to have far-reaching consequences, not just for the company, but for the stakeholders. Every decision they make is going to be under the spotlight, and every decision they make may well, from a legal perspective, attract personal liability. So a challenge. And that graph there is really just to show that it's anticipated that South Africa's economy may well contract up to 10% by the end of the year, which is again why value creation is so critical. So that's just, I think, no easy task for boards to have to deal with. So if we go to the next slide, the D&O market started changing, I'd say, mid-2018. And that was off the back of a massive increase in claims, both in severity and in frequency. But also what we were seeing is that there were a number of trends that were starting to emerge, which even then in 2018 began to worry insurers. And we saw that these trends continued unabated into 2019. And now with Corona, they are very, very worrying to insurers. I think what insurers are scared about is that your pure traditional directors and officers claims, you know, your securities class actions, your pure financial claims, this is when the share price reacts negatively. Those sorts of claims are actually going to dissipate. And that's because of the effects of Corona from an economic perspective. But what we think we're going to see is that D&O claims will continue off the back of some of these trends that I've got highlighted here. So the first one is what we call event-based or bad news litigation. And this, I think, started with the Shell oil spill. It started with the VW emissions scandal. And so what we're seeing is that plaintiffs' bar, these are plaintiffs' lawyers, are now starting to sue directors following an adverse event within the company, whether that's a cyber breach, whether it's a product recall, a listeriosis as an example, whether it was off the back of the California wildfires, and I'll touch on that matter just now, of course, off the back of the hashtag #MeToo movement, and now one that's gaining momentum, the hashtag Black Lives Matter, and now, of course, Corona. So what plaintiffs' bar is doing is that they're taking the event and they're tying it back to comments and statements that the board has made around management and mitigation relative to that particular exposure, and are then suing the directors for things like misrepresentation, for lack of disclosure, and for breach of oversight, of the oversight duty of the board. The problem for directors and officers insurers is that it's impossible to actually underwrite this risk, because bad news can happen, adverse effects can happen, a fire can happen, a cyber breach can happen. And so it's very, very difficult for them to underwrite. And unfortunately, with Corona, I think we're going to see a massive increase in litigation against boards off the back of just events that have happened. The other one is ESG issues, and particularly how that affects reputation. I mean, we all know that civil unrest and social justice have become key themes in 2020. You know, anyone who's following the US election can actually see the massive impact that it's having on corporations, the civil unrest and social injustice. And I think this is the trend that is also really, really scaring directors and officers, insurers and their reinsurers. So we've already seen a couple of claims in respect of climate-related risks. There was a company, PG&E. This company had stated in their financials that the California wildfire risk was heightened, and yet they hadn't taken any measures to really address that from a risk management and mitigation perspective. They were subsequently sued and are now no longer. The company was placed into liquidation. We've seen plenty claims off the back of #MeToo. I think it's a matter of time before we see claims off the back of Black Lives Matter. What's worrying insurers post-corona is, of course, claims alleging unsafe working conditions and how we return to work, discrimination claims arising from those that cannot return to work. And of course, because of the economic effects, we do think that we're going to see a massive increase in claims for unfair dismissal as these companies have to ultimately downsize and downscale. I think diversity is also going to be a massive issue. Now, we talk about social media temperature and reputational brand, and this is something that insurers, from an underwriting perspective, are really, really focusing on. You know, it's no surprise that in 2019, Elon Musk decided not to renew his D&O policy for Tesla because it was simply unaffordable. The premium was ridiculous. And one of the main risks that the insurers were uncomfortable with was off the back of a tweet that Elon Musk had tweeted, stating that he had funding over a capital raise that was imminent, when in fact that wasn't the case. It's also no wonder that this year Tesla have renewed their D&O policy, albeit with an Elon Musk exclusion on the wording. So, you know, insofar as reputation and social media goes, never been more critical post-COVID. You know, just look at the clicks matter in South Africa. That speaks to ESG issues, reputational brand, and the social media temperature. And so I think it's safe to say that reputation's never been more important. You know, one bad customer review, one #MeToo lawsuit, even some negative tweets from the board is going to have massive consequences for the company and even possibly for the directors. So insofar as securities class action is concerned, there are currently in the US over 600 open securities class actions. In South Africa, we've never had a securities class action, and I'm going to probably at the end of this talk make some statements that I think might be controversial. But I do think that the time has come when we cannot lump South Africa with the rest of the world insofar as securities class actions are concerned. We haven't had any. And who knows, maybe we don't even need the cover in South Africa, given the way that our law is panning out. But the fact of the matter is there are 600 open claims, and this is what essentially drives the D&O market. The securities class action reform is on the cards in the US because something has to be done about it. It's really running riot. But I think until that happens, we will continue to see around 400 cases a year in the US alone, and that's sort of the average. Chubb globally have estimated that the costs of securities litigation in the US over the past 5 years, just in fees and settlements, to be around $23 billion, with half of that going to fees. So this is very profitable business. And that talks to my next point around litigation funding. Litigation funding has found its way into South Africa. We know the recent matter, this recent Steinhoff matter, De Bruin versus Steinhoff, and I'll get to that just now. But in that matter was litigation funding. Now there was some legal issues with the litigation funding, but what that matter has sought to do is to pave the way for other litigation funders to come into South Africa to learn from the mistakes that the De Bruin litigation funders did, and paves the way for more litigation funders to come into South Africa And I think that's really scary insurers. Litigation funding, make no mistake, is massive business. It's big business, and we're going to see it grow from strength to strength, simply off the back of COVID, where many plaintiffs will just not have the money to litigate. They may well have a really good claim, but they may not have the money to litigate. And so litigation funding is a trend that's really worrying insurers. And finally, the economic recession and increased insolvencies. So what insurers really stress about when it comes to insolvencies, and particularly in South Africa off the back of business rescue, is of course when you place a company into business rescue, you essentially are opening the cupboard. We don't know what skeletons we're going to find when we do that. We also don't know how directors answer the question as to how they managed and mitigated the risk of insolvency. Did they trade the company recklessly while the company was still solvent? And so what insurers worry about is claims by business rescue practitioners, claims by shareholders, and of course those all-important Section 417 inquiries, should they happen post-liquidation, where the skeletons are really laid bare. So they are petrified of the increased insolvencies, and unfortunately post-COVID, that's just going to be a reality. So these are some of the trends to watch, and of course there are others, but I thought I'd just highlight the most important ones. So if we move to the next slide, I think a lot of what I've said is repeated here, but you can just click again. The picture should come up. Thank you. And I mean, these are sort of some of the actual claims that we've been dealing with. I can say in South Africa, we do have claims. You know, one thing that we're not very good at, which Marsh is trying to change, and we're working very hard, is to get some really meaningful data around D&O. For now, our benchmarking data is largely UK-based, but we are working on algorithms and data analytics to really be able to analyze what's happening in the South African marketplace from a D&O perspective, because that will then drive sort of the state of the market. And without data analytics, we're really wholly reliant on what the rest of the world is doing. So shareholders are suing for allegations of inadequate risk management and risk mitigation, ineffective business continuity plans. Stakeholder activism I've highlighted because I really think this is the one to watch going forward. You know, and again, there'll be lots of allegations around lack of disclosure, inadequate disclosure, and an absolute focus on the board having to mitigate and manage their risk. We've already seen regulators this year being a little bit more active. We know that the JSE, of course, recently fined Tongaat Hewlett off the back of their accounting scandal. We know that the Competition Commission fined Dis-Chem earlier for overpricing of their masks right at the beginning of COVID or the lockdown. And that's going to continue unabated as well. We are going to see claims from employees around unfair labor practice, unfair dismissals, and safe working conditions. The one thing I want to highlight is shareholders and customers specifically as it relates to cyber. I mean, it is in the public domain, so everybody will know, but earlier in the year, you know, Life Healthcare, which is a very special Marsh client, was unfortunately the subject of a horrible cyber breach, probably one of the biggest that we're going to see or certainly have seen to date. And I was very fortunate to be involved in that matter from day one. And I have to stress that from a directors and officers perspective, you know, it is a real threat to have a cyber breach, not be able to justify or not be able to manage and mitigate the cyber breach properly, and not be able to justify the statements that you have made as a board around your safety and controls, apropos your cyber. The other thing that we've seen is that a cyber breach, certainly the magnitude of Life Healthcare, if not for cyber liability insurance, would have possibly crippled that business. So if you're a small business, if you're a private company and you don't have cyber liability insurance, in other words, if the board has not made an active decision, now that Poppy is law, to actively something come up on my screen, to actively transfer the risk through cyber liability insurance, I think boards are going to have to answer some very, very difficult questions. You know, we have seen over 100% increase in the number of attempted attacks since April 2019, and certainly off the back of COVID with work from home, these are also going to increase. So I cannot stress enough how important it is for boards to focus on cyber resilience, to focus on data security measures, to make sure that what they are saying to their stakeholders is in fact true. And then, as I say, to ensure, now that POPI is law, to transfer that risk through cyber insurance. We've spoken about customers, we've spoken a bit about regulatory inquiries, and I think these will continue. And of course, business practitioners and liquidations are going to continue. So all in all, lots and lots of opportunities for plaintiffs to sue boards. If we move on to the next slide, I just want to highlight some of the Covert claims, and this is this is data as of October 2020. So in the US, we've seen 4 securities class actions. We've seen 2 claims against cruise liners. The first, of course, was the Norwegian cruise liner, and the CEO, CFO were sued for false and misleading sales pitches, underplaying the virus right at the beginning. We've seen 3 securities class actions based on company statements relating to vaccines. The biggest one was Invio. These were the guys that claimed to have an imminent vaccine right at the beginning of lockdown. Of course, their share price rallied. They then came out a few days later to say, in fact, that wasn't true. The share price tanked, and there was a securities class action. We know Zoom had their massive cyber breach right at the beginning. And again, the CEO, CFO were sued relating to their statements that they had made about their privacy and security. We've had 2 and the shareholder derivative actions, including Zoom. The interesting thing in the US is that there's been 4 SEC enforcement actions, particularly relating to PPE. And the most recent one is Kodak. So Kodak there has been sued as a result of questionable stock dealings just prior to a federal loan of $700 million to produce PPE materials. That loan has now been overturned off the back of this SEC enforcement action. So you can see that there are certainly claims coming as a result of COVID. Given the long tail liability nature of D&O claims, these will be around for some time to come. And of course, given what I've spoken about before, we can anticipate lots more. What I will say though, is we have seen 0 private company lawsuits and certainly 0 claims in South Africa to date, specifically off the back of COVID. So if we move to the next slide, I think that boards have got to take heed of the business judgment rule because it is going to be critical. How boards plan, how they think, how they act, and how they decide post-COVID is going to be very, very different. And whether it's a capital raise, whether it's a merger and acquisition, whether it's closing a subsidiary, whether it's restructuring the business, when boards are having to make these crucial decisions, when they are having to exercise their business judgment, they're going to have to be very cautious about how they make those decisions, particularly in the light of risk management and risk mitigation and some of the adverse event litigation that we're seeing. I do think that judgments are going to be challenged. So business judgment is going to be challenged. And I do think that directors' decisions are going to be challenged going forward. And so the business judgment rule is going to be critical when defending your duty of skill and care as a director. When we talk about diligent steps to become informed, the board is going to have to evidence that they have taken those steps. They've asked the relevant questions of the relevant experts. Obviously, no personal financial conflict of interest, and that is abiding strictly by Section 75 of the Companies Act. And the final one, when taking the decision, genuinely believing that you are acting in the best interests of the company will be objective and subjective. Now, what the interests of the company are going to look like post-COVID-19 in this new era of value creation, I think is going to be a very interesting space to watch. And I think what boards must do and should do is to continuously rely on experts to assist them when making their decisions. So we shouldn't underemphasize the importance of the business judgment rule going forward. So I think if we go to the next slide, that leads us into the state of the D&O market and why I'm not looking as good as my photo, you know, and having to visit the hairdresser for tints more often than before. Stress will do interesting things. Sorry, let's just touch on these judgments. So these are very important. I will say that the Glumisa versus African Bank matter is on appeal at the moment to the Constitutional Court. And that's maybe not a bad thing because we do need clarity ultimately on the interpretation of Section 218 of our Companies Act. And that is the section that deals with civil damages against directors. But both in De Bruyn and in the Glumisa matter, the court ruled that directors owe their duties to the company and not to shareholders. There is a thought out there, there is a school of thought out there that says that from a governance perspective, we are possibly moving away to directors' duties being owed to the shareholders. Our law does not say that, and I think these two judgments have clarified that. But the interesting thing is what both said is that the loss of value is the loss of the company and not that of the shareholder. So in both of these matters, De Bruyn being a shareholder and Glumisa being a shareholder, they sued the board of directors for loss of share value off the back of breach of fiduciary duty, off the back of other breaches of certain sections of the Companies Act, including Section 218. And what the court said is no, the loss of share value is actually not the shareholder's loss. It's the loss of the company, it's the reflective loss principle, and it is the company that must sue for that loss against the directors. So the company must sue the directors. And the way that the company does that is, of course, through the derivative action in terms of Section 165. Now, we have had some derivative actions in South Africa. I've personally dealt with two, albeit they were actually in the private sector space. But it's a difficult action to bring. That's not to say we're not going to see derivative actions happening. The court has said this is the better solution to bring these derivative actions. But I think where insurers are worrying is that these derivative actions will probably be litigation funded. And that's what they're scared of. So as I say, these are very important judgments that shareholders cannot simply sue directors because they've lost share value. The court says they need to do that derivatively and then follow Section 165. The other thing that they did is that says that Section 218 of the Companies Act does not alter the common law and does not allow for reflective loss claims to be brought under Section 218. And again, we need finality on the interpretation of 218, and maybe Glumisa is going to the Constitutional Court. It is one of our matters. I know that we are waiting for the court to rule as to whether, in fact, it can go to the Constitutional Court. I've just put a reference there at the bottom to a MoneyWeb article which discusses the Glumisa matter. It was quite a good article. Okay, so if we move to the D&O market, and I want to get through that quickly so to allow some time for questions. The D&O market is horrid. There's no other word for it. As I said to you earlier, I remember the days where we had 3 billion rands worth of capacity locally in South Africa. Unfortunately, that's reduced probably by half. What we're seeing in the market is that there's no new capital coming into the market. In fact, to the contrary, we've seen insufficient capacity. In the past year alone, we've lost over $500 million in D&O capacity in the London market alone, as we've seen in excess of 7 markets simply just close up shop, put their books into runoff, not writing commercial D&O anymore. It's not uncommon for me to sit before a board or a risk manager or insurance manager these days and have to try and sell a triple-digit premium increase. My largest increase probably around 300% this year alone. What we're also seeing, unfortunately, is exclusionary language finding its way back. So I mentioned earlier that in the good old days, we as brokers sold ourselves on the breadth of the cover that we were able to secure. That's not happening anymore. We're starting to see pandemic exclusions. We're starting to see insolvency exclusions. We're starting to see insured versus insured exclusions where the company cannot sue the director. And we're also starting to see what we call specific matters exclusions, like the Elon Musk exclusion. I cannot stress this enough around the increased underwriting rigor. It is painful, and underwriters are asking a lot more questions than they have before. In the good old days, we sent a proposal form and a set of financials into insurers, and off the back of that, we got a quote. That's not happening anymore. A lot of questions around COVID response, a lot of additional questions around breach of debt covenants or debt covenants in general, a lot of questions around board changes. Why are the board changes happening? And a far, far deeper dive into the business than we've ever seen before, for very obvious reasons that, you know, we've spoken about this morning. There are significant appetite restrictions. So when we are building a D&O program, and particularly the large programs where they buy big limits, you know, in the good old days, we would have a primary insurer maybe taking a $10 million line. In South Africa, maybe taking a $250 million primary. Now what we're seeing is some insurers only renewing on a $2 million line. If you look in South Africa, AIG as an example was writing 250 million Rand primary. They now write 150 million. They've halved their capacity. So what we have to then do is find additional insurers to stagger or to stack the program. And that's proving to be very difficult. The other thing that we're seeing from a pricing perspective is that your excess layer insurers are actually starting to charge more as a rate online than the primary insurers. They're charging what they like. You know, and again, in the good old days, they would follow the underlying pricing of the primary. That's not happening anymore. Your excess markets are simply charging what they want and also placing certain restrictions on their layers. So it's becoming increasingly difficult for us to layer these programs, and very, very challenging indeed. The other thing that we're seeing from a retention perspective, without getting too technical, remember D&O covers side A, side B, and side C. Side A being your personal indemnity, side B being company reimbursement, or that is where the company indemnifies the directors and then claims back that indemnity. And side C is securities entity cover. This is cover for the business, for the entity when sued for breach of securities regulations. We've never had a side C claim in South Africa, your typical securities class action that I spoke about earlier, you know, the 400 that we see in a year in the US. And so what's happening with these retention increases is because these claims tend to be very, very large and against the company as well as the directors, is that the excesses are increasing incrementally. In fact, sometimes up to 10% of the limit. So it's not uncommon for me to sit these days before my clients and try and sell a 15 million or 20 million Rand excess for side C. But that's just how the market is turning. As I said, we've seen insurers withdraw from the market. We've got a capacity crisis on our hands, and we've been through the litigation, changing litigation and regulatory landscape. So all in all, you can see why you know, we're so stressed and why we've never seen a market like this. Unfortunately, it's going to continue. We don't see signs of the markets relaxing anytime soon, and certainly not within the next 18 months to 2 years. So just to end off, you know, you may be asking, well, what can I do to prepare for my upcoming renewal? If I've had a difficult renewal this year, you can still expect a difficult renewal next year. So the first thing that we're advising our clients is to start early. And when we start early, we mean 6 months. We are already in the market 6 months in advance with some of our larger clients as we prepare them and prepare the market for their renewals. The next one is to prepare a quality submission. And I cannot stress this enough. You need to tell a good story about your business. At the same time, what we're doing is we're involving the C-suite where necessary. We are doing underwriting meetings and underwriting presentations. And of course, with Zoom and Teams, it's perfectly possible to do that. You know, we've renewed global programs over Zoom and over Teams and over other mechanisms as well. So it's important to involve the C-suite and let the CEO tell the story. Let the markets hear from the horse's mouth. They really, really do appreciate that. So prepare a quality submission and get the C-suite involved if needs be. The other thing is to definitely involve a specialist to broker the risk. And I have to say that this is the one time where size and where market relationships really do count. Because if you don't have a specialist batting for you who really understands the nuances around this class of insurance, because it is a highly, highly technical class of insurance. You know, it's no good accepting an insolvency exclusion if it's going to affect a future claim down the line. It's no good accepting some of the exclusions that we're seeing and some of the exclusionary language. You really need somebody in your corner to fight for you. Otherwise, insurers are going to take advantage. It's as simple as that. And I think the final thing and the message that we're trying to convey to our clients is understand the market conditions, you know, and hopefully the data analytics that we're working on will assist our clients in understanding the market conditions. Hopefully this talk, you know, will assist clients in understanding that when you do get those triple-digit increases, it's not you, and that's very important to understand. It is unfortunately indicative of the global market, which then of course filters down to South Africa. So it's not you. Don't take it personally, as many of our clients have. It's not your board that's terrible and horrible, which is why you've received such an increase. It really is being driven by the market conditions. So I think final slide going forward, you know, a lot of people are saying, my word, what is going to happen to the future of D&O off the back of some of these trends and some of these stats that you've spoken about? You know, the average settlement in the US, cash settlement, is sitting at $13.6 million. That's a lot of money in rands any way that you look at it. So I think the future of D&O will always be around getting that balance between demand and supply. Of course, I think the demand is at its highest than it's ever been, and yet supply is definitely shrinking if we look at the capacity concerns. And so that means that insurers are able to charge a lot more and charge what they want. So ultimately, I think it'll be a decision around what's affordable for the board, and also very importantly around what they want the D&O to actually do for them. And there we talk to structure of the D&O policy. Do they want some more side A cover? Or do we do away with side C cover altogether if we're a listed company? And these are the kind of discussions that we need to be having. But ultimately, and perhaps this is a little bit controversial, and certainly discussions that I'm having with my insurers quite strenuously, and that is that if you look at South Africa, no matter how many times I'm told we're not unique, we are unique. We are not litigious. We are not nearly as litigious as other parts of the world, like the US and the UK and Australia and Canada. Not at all. Our law does not allow shareholders to sue for loss of share value. We've got to do that derivatively, and that brings in all sorts of other issues. We have never had a securities class action in South Africa. We don't have any major class actions against boards of directors to speak of. We've had class actions, but they've been against the company. And so my view to our local market is that you cannot put us and look at us in the same light as the rest of some of these jurisdictions. And so the SA-specific risk must surely count when renewing some of these big programs and even small programs as well. We cannot be lumped with the rest of the world. And I keep saying to my markets, you cannot be like sheep and follow the herd just because everybody else is doing it. You need to look at our local conditions, you need to look at our local circumstances, and by all means, you then need to price the risk realistically. So it's a bit controversial, and we're having lots of discussions and debates with our markets, but I really feel passionately about this. We cannot be lumped in the same risk categories as some of the other parts of the world. Yes, we have our own unique circumstances and challenges, specifically off the back of some of the claims we're seeing in the state-owned enterprise space. Indeed, we have our own challenges, but I do think that the local market should not follow this herd mentality and should start looking a little bit more at our specific risk. Good. So that was my last slide. I see that there are some questions, so I'm just going to try and read them. In light of bad news litigation, how often should directors review the company's risk tolerance and appetite thresholds? That's a great question. I think the answer is it's ongoing, and boards should never become complacent when reviewing their risk tolerance and appetite. It's an ongoing thing, but I certainly think on an annual basis, given some of the changes that we're seeing, it's a good idea to do those exercises. Have you heard of a case where the board sues stakeholders? So we are dealing with some claims where the company is suing its own directors. You would have certainly read in the press how Tongaat Hewlett is going after some of its past directors, particularly the CEO and CFO. And there we're seeing the D&O policy responding. But have I seen a claim? I have no doubt that directors do sue stakeholders, particularly things like customers, but I'm not sure, but the D&O policy, of course, is not going to respond to those kind of claims. The D&O policy it's a legal liability policy, and it responds to claims made against directors. How effective is the cyber attack insurance cover? Anusha, it is unbelievably effective, of course, if you have the right cover in place. I mean, if we just look at the life healthcare matter, and I can't talk too much about it because we're still in the midst of finalizing the claim. But the most important thing around cyber liability is that emergency response cover that you get. Within the first 48 hours, we had a team of experts that descended on life healthcare, from legal experts to insurance experts to, of course, IT experts, all working with the business to manage and mitigate and try and close down and understand where the breach had occurred. The insurance covered that emergency response, and that was many, many millions of rands. So it's critically important to have cyber liability insurance. Remember, the cyber also covers the business interruption risk. We're in the process of quantifying that business interruption risk, and that can also run into many, many millions of rands. So in my experience, having dealt with a few of these big cyber claims, I would say that cyber insurance is an absolute must. Absolutely. Does what you say about D&O insurance and expected behavior apply to NPOs? Oh, absolutely. Absolutely, it does. Our Companies Act, our law doesn't distinguish between directors and officers of listed, private, or non-for-profit organizations. There are certainly claims against non-profit directors, lots in the US and lots, interestingly, in Australia. Not too many in South Africa, but certainly, from a governance perspective and a risk mitigation perspective, it applies equally. Joy has asked, do you think insurers want to see more professional directors? In other words, directors who have some form of formal training, like IOD certified and chartered directors. Joy, I think that's a brilliant question. And if I had to put an underwriting hat on, I would say yes, absolutely. Especially if you look at some of the challenges, coming down the line. And we're definitely seeing insurers start to ask a lot more questions around directors, particularly directors that have been on some suspect boards, and are popping up. And we see that unfortunately happening in the state-owned enterprise space. So yes, I think the answer is yes. Can you assist with the best ways or guidance to involve the C-suite? So yes, I think what we're seeing is if we get access to the CEO or the CFO, those are really, and sometimes even the chairman wants to be involved in the D&O renewal, which we really love. But the ways that we do that is to ask the CEO or the CFO to prepare a presentation and give a presentation to a panel of D&O insurers, where they will address things like the financial status of the company. They'll address things around governance, around risk, around what they're doing to manage and mitigate their exposures, and just to tell a good news story. And we're finding that that really, really helps when it comes to underwriting the risk. Tyrrell has asked, if the company must sue the directors as per the court rulings, does it make sense that the company takes out the insurance? Won't this conflict the decision to sue or not? It does indeed, Tyrrell, and that's why we have the derivative action. it's not an easy action to bring, because you do have to bring an action to court. So you have to have leave of the court in order to force the company to sue the directors. But the reason that we take the policy out in the name of the company is so that the company pays the premium and not the directors in their individual capacities. Remember also, our Companies Act does allow for companies to indemnify directors, and that, of course, subject to certain exclusions, but that indemnity then also extends to the directors and officers cover. Also, the reason that we buy the policy in the name of the company, particularly in a listed space, is because there's Side C cover available to the company when it's sued for breach of securities regulations. Hi, Mpho, how are you? Should we expect insurers to impose bankruptcy exclusions when policies are renewed? What would South African companies with US subsidiaries expect to see? So we are seeing insurers impose bankruptcy exclusions. And certainly in South Africa, we are seeing a lot of insolvency exclusions being placed onto local policies. Again, that comes back to my previous closing point, and that is, why impose an insolvency exclusion just because the financials off the back of COVID and the most difficult trading conditions we've ever been in don't look so good? That doesn't mean that there's an insolvency risk. But unfortunately, we are seeing insolvency exclusions, more so in South Africa, interestingly, than I've seen in the UK, and more than I've seen in the US. Mpho, I've lost your question, but I think you asked something about subsidiaries. Sorry, maybe we can take that one offline, because they're scrolling up as they're coming along.
Sorry, Teri, she wanted to know whether SA companies with US subsidiaries could expect going forward.
Yes, so South African companies with US subsidiaries are finding it very difficult to renew their cover locally, because South African markets, from a treaty perspective, cannot write US jurisdiction. I think we've got 2 markets in South Africa that can write US jurisdiction. What we're seeing is that we're having to send those risks into the London market. And again, based on the financial status of the company, insurers will decide whether to impose insolvency exclusions or not. Let's see what else. What is your view on the recent happenings with Xperia? Who should be held accountable, as the company benefited from the sale of their clients' information? And a good question. I think a lot more information needs to come out around what happened at Xperia, particularly around how the breach happened. And I think some questions need to be asked of the board as to what their mitigation and management around data security and data privacy looked like. So I think that's one to definitely watch. Nanda is asking, I noticed a number of companies and SOEs borrowing more with increased debt levels and interest levels, with decreasing revenue and payment levels. Does D&O cover companies and directors' liability due to cash flow, liquidity, and going concern issues that have not been properly or diligently considered? Well, the answer is subject, of course, to the policy terms and conditions, but subject to how the claim is brought. Yes, absolutely. And I go back to the days of the CNA versus John Newton matter. That's way over a decade ago, one of our first D&O claims. But there's lots of questions being asked around boards where they do take on additional debt levels, where they do have to raise additional capital to keep the company afloat. And ultimately, if that company fails, then questions are going to be asked of the directors. Did you consider liquidity and going concern issues properly in accordance with the Companies Act? And if you didn't, and you traded this company into insolvency, taking on more debt when you knew you would never be able to repay it, then absolutely there might be claims by shareholders and other stakeholders. And that's exactly where the D&O would respond to the legal defense costs of those sorts of claims. Paco, you asked, if I heard you correctly, you were saying that shareholders should not sue for loss of value of shares. They should sue it derivatively. So yes, excuse me. what the court has said is that it's not that shareholders should not sue, but shareholders cannot sue directors directly for the loss of their share value, because the loss of that share value is the loss of the companies. It's called the reflective loss principle. And so what shareholders need to do is they need to bring a derivative action, which forces the company to sue the directors for that loss. That's what I'm saying. What will happen to liability cover after a board membership? In other words, if the company is sued for a decision was made, I'm still a member of the board. Okay, so that's an important question, because the decisions that boards make today are not going to be questioned tomorrow. They'll only be questioned in months and years to come. And you may well not be on the board, you know, when that decision is questioned. You may have been on the board at the time. So as long as you have a D&O policy in place at the time that the claim is made against you, then the policy will respond. The policy should respond. The definition of directors and officers or insured persons under D&O policies generally do include past, present, and future directors and officers. So as long as you have a policy in place, because it's a claims-made policy to respond, and the claim arises within your retroactive period, then the policy will still respond to that past director. If the chairman makes a financial decision without board approval, is he liable if the company is sued? I guess it depends on how that claim is made, by whom that claim is made. But the policy may well respond to legal defense costs if the chairman is sued. And again, it depends on who he's sued by. No chairman should be making financial decisions without board approval, should they? The one thing that I will say is if that financial decision is based on fraud or is based on gross negligence, then the D&O policy will not respond. So one of the things, remember, the D&O policy covers legal defense costs until what we call final adjudication. And that's another big topic that's happening or being debated in D&O at the moment, is should D&O policies continue to defend a director until final adjudication, where it is pretty obvious that what the director has done is tantamount to fraud, and therefore should we not be invoking the conduct exclusion, which excludes theft and fraud earlier on. And so there's a lot of debate happening around that. But certainly if the decision was made fraudulently or with gross negligence, then no, the policy wouldn't respond to that individual. Simpiwe, what is a reasonable level of cover for cyber insurance? If I had an algorithm that answered that question, I think I'd be holidaying in the south of France next year. Simpiwe, it's a great question, and I think one that boards are going to have to pay a lot more attention to. In order to arrive at the right level of cyber insurance, you're going to have to do a deep dive into your cyber risk. What is the risk? What are the mitigation strategies you have in place? What is the data security and your security mechanisms that you have in place? This can be done on an actuarial basis. I don't want to sort of plug Marsh Risk Consulting here, but our risk consulting team, our cyber risk consulting team, does exactly this on a daily basis. So they will do cyber risk assessments, particularly around the insurance values. Andrew is asking, in RSA, is there a difference in the incidence of litigation against directors in public versus private companies? And if so, does this affect the cost of insurance? So in my experience, I have dealt with claims both in the private and the public sector as well. In private companies, interestingly, is where we've seen the derivative actions being brought. Obviously, the public companies or the listed companies tend to be much larger claims. You know, if you consider African Bank and Steinhoff and those kind of claims. It does affect the cost of D&O. So obviously, private companies don't have the Side C exposure, the securities entity exposure, and therefore that definitely does affect the cost of their insurance. So to answer the question, yes, if you're a private company, you're going to pay less than, of course, if you're a public company. One of the other issues that we're looking at in a big project we're embarking on next year is what D&O insurance is going to look like for state-owned enterprises, because at the moment, you virtually can't buy it for obvious reasons. But again, there's some good apples and there's some bad apples in the state-owned enterprise space. And so what we're trying to do is develop a product, or at least go back to basics in ensuring that directors of state-owned entities still have access to D&O insurance, because at the moment that's proving to be virtually impossible. Godfrey's asking, is the cyber liability cover for the company or is there cover for the directors? So Godfrey, the cyber liability will cover the company, but remember, if the directors are sued off the back of a cyber breach for, as I said, lack of disclosure or lack of risk management, then the D&O policy will respond. That's where the directors will be protected. With the insurance hardening, is it feasible for SMMEs to budget for D&O and cyber cover? Our law doesn't distinguish between directors' duties with respect to listed or public, private, or not-for-profit companies, nor for whether they're big or small companies. So my view is always going to be that directors and officers must buy insurance to protect their personal exposures. I do think that they need to budget for it. I think cyber liability, as I mentioned earlier, can very easily cripple a business, and we've seen it happen in South Africa on more than one occasion. So the answer is yes, budget as best as you can, but it's an affordability issue. You're going to buy, I guess, as much as you can afford. Carolyn, I think I've answered your question around SOEs. AIG is pretty much the only market that is willing to write primary for SOEs at the moment. So it's becoming increasingly difficult. We look after some of the very, very big ones. What we're also finding is that we're having to scour the world for capacity, not just the London market. We're looking at the US market, the Singapore market. We're even looking at some of our markets in the MEA region, Middle East. Okay. I'm just watching the time. Just please tell me when I'm going over. So I'm just going on and on.
Thanks, Teri. A few more questions, and maybe they keep popping up more. So maybe I think have a look and answer one or two that
okay.
Some of them are quite similar to what you already answered already.
Yes. Okay. SIA, the South African Occupational Health and Safety Act limits employees from suing their employers. Would the post-COVID-19 corporate legal liability change, perhaps through increased class action approach? Yes, health and safety limits employees from suing their employers, but it doesn't limit them from suing the board of directors for lack of oversight and for unsafe working conditions. So, there's not to say that there won't be actions against directors and officers if they fail to provide a safe working conditions. And we're already seeing claims coming in the US as a result of that. How would you advise NPO or organizations that rely on volunteers like sporting federations continue with directors and officers insurance in the face of affordability? I think, Sylvia, we've sort of discussed that. One needs to buy as much as you can afford. It's difficult. But one needs to buy as much as you can afford. Can trustees of medical aid schemes obtain D&O insurance? From Robin. So Robin, under the Medical Schemes Act, you are required to have separate crime and professional liability, and medical schemes will have a separate trustees liability policy where they will be covered in their personal capacity. So not for the domain of D&O, but certainly for a separate policy where they would be covered in their personal capacities. Joshua has asked, what happens to past directors if ensuring the company ceases to exist? Good question, Joshua. So what most policies will provide is what we call automatic runoff cover for past directors. our wording, the Marsh agreed wording, actually covers directors, past directors for their lifetime, even if the company ceases to exist. So you would want to ensure that your D&O policy has adequate run-off cover for past directors. And finally, Louisa has asked, since South African law requires the company to sue directors for loss of value, should the directors be considering taking out personal cover given the insured exclusions that are emerging? Good question, Louisa. Obviously, we try and avoid that insured versus insured exclusion at all costs. I see no relevance otherwise to buying insurance. You know, if the company can sue directors and the policy doesn't respond, that makes no sense. But the question about personal cover is a difficult one because in the South African market, there is no appetite for selling individual personal, for underwriting individual personal policies. So the answer really is to try and avoid any kind of insured versus insured exclusion at all costs. And I think, Vikeshni, that's all the questions that I've got. And I see no open questions.
No, thanks, Teri. I think we've answered majority of all of them. Thank you so much, Teri, for your.
So one last question, one last issue. We have prepared a 3-minute D&O 101 video, which I have sent the link. I don't know if you want to play the video or you email the link to everybody, but it's just a D&O 101 for those of you that sort of haven't purchased it before or are not totally familiar with it. So please go ahead, have a look at that video and feel free to reach out to me anytime.
Thank you, Teri. I'm going to ask Cindy or Vasani to please just put that link in the chat group so that everyone can access it there and they can play that. There we go. Vasani's just put that on to the chat group so you can open that link and it'll open up for you. We also will include it in the email that we send to everyone. And I think maybe what we'll do, we might just add it to this last page here before we put that onto our website so that if anyone does see the presentation, they also have access to the video. Teri, thank you so much for a very informative session. I think everyone enjoyed it. You've answered some questions I think everyone has in mind, and I'm sure you will be getting a lot of contacts going forward for further questions and answers as well. Always a topic I think that we get a lot of questions on as well. And I think we've got some nice ideas, I think, from the session to potentially look at some further guidance notes through our boardroom governance forum. So I'll definitely be in chat with you and we'll see if we can provide more, I think, guidance to the public on some of the topics you mentioned. So thank you once again for joining us. I think I may have lost you. Looks like you've frozen. Okay. Thank you so much for joining us, Teri, and giving us your time. We hope to have you again soon, and thank you for everyone joining us this morning. As I mentioned, the video and the presentations will be on our website and the YouTube channel. And the team will... Go ahead,
Only
Teri.
a pleasure. I'm getting my... Sorry.
We can hear you now. Go ahead. I think our connection, we've lost Teri. I think our connection is a bit bad at the moment. So thank you everyone again for attending, and I will see everyone same time, same place next week. And I hope everyone has a wonderful week ahead. Thank you. Goodbye.